I turn to consideration of any statutory or other mitigating factors. For this purpose, you have provided minimal assistance to the court. To the author of the pre-sentence report, you continued to deny that you were Rhiannon's assailant, showed no empathy for the victim, and provided a limited account of your life in Sudan before your departure. To the consultant psychiatrist who examined you for a report in March 2025, before your trial, you were unwilling to discuss your past medical history and very guarded in what you said. For the age assessment process, you refused consent for disclosure of your medical records. During the 2 age assessment interviews, you then refused to answer many questions, including those about events in Sudan. Your refusals were typically preceded by the words, "Thank you for the question." The authors of the report described your provision of information as one of strategic selectivity. They observed that throughout the 4 hours of the interviews, your posture and demeanour were confident, controlled, composed, and relaxed. In the results, you have provided the court with no explanation for your conduct, nor any reliable basis to consider any suggested mitigating factors. I see no basis for the statutory mitigating factor which arises where the intent was to cause serious bodily harm rather than to kill. Having regard to every aspect of your conduct before, during, and after the assault on Rhiannon, I am sure that your intent was to kill. In my judgment, your age and level of maturity provide no mitigation. The evidence shows a level of maturity which is consistent with your true age, and indeed a chilling composure in every aspect of your behaviour. Your counsel then points to the agreed fact that you have no previous convictions in this or any country, to your accounts of your life in Sudan and consequent departure from that country, to an aspect of your physical health which, as I accept, is established, to suggested mental ill health, to limits on your command of English, and to the prospect that your time in prison may be more onerous than for others. In my judgment, your accounts at the trial and otherwise about your personal circumstances in Sudan are unreliable. You have refused consent in respect of medical records and failed to engage with a consultant psychiatrist. I have no doubt that your English is better than you suggest. In any event, if all these matters were established by reliable evidence, they provide no mitigation whatsoever for what you have done. In your case, there are no mitigating factors. For count 2, the associated and overlapping offence of possession of an offensive weapon, no separate penalty will be imposed. The surcharge provisions apply, and the order will be drawn accordingly. Deng Chol Majek. On the count of murder, and as the law requires, the sentence is imprisonment for life. I turn to the minimum sentence which you must serve in custody before you may apply to the parole board to be considered for release. Having regard to all the matters to which I have referred, I set that minimum term at 29 years. From this must be deducted the 466 days you have spent on remand in custody. This means that the minimum term you will serve before you can be considered for release is 27 years and 264 days. Yes, please take him.
On the 20th of October 2024, Rhiannon Whyte was brutally and senselessly murdered at Bescot Station as she made her way home from work. Her killer may have been sentenced to life in prison today, but no sentence or outcome will ever really be justice for Rhiannon's family and friends, who continue to live with this insurmountable, horrific loss. Their own life sentence began in October 2024, the moment Rhiannon was brutally taken from them. It was a frenzied, sadistic and unprovoked attack, which her killer carried out on an innocent young woman he barely even knew. He laughed, danced, joked around in the moments after what happened, and to this day he's never shown any remorse or given any explanation for why he decided to murder Rhiannon that night. His callous indifference has played out every day in court for Rhiannon's poor family to see in person. I would like to pay tribute to them once again for the extraordinary strength and dignity they continue to show in the face of one of the most truly traumatic things a family could ever have to go through. I have no doubt that Rhiannon would be immensely proud of them. As we close this chapter, it is important to remember Rhiannon for the person she was. Her kindness, her energy, and the joy she brought to those around her, rather than the person responsible for her death. Today's sentence ensures he will face the consequences of his actions, but it is Rhiannon's life and legacy that should live on. Thank you. Yes, ATTWELL. Thank you very much.
I stand here today to represent myself, our mother, our other 3 siblings, Emma, Daniel and Cara, as well as Rhiannon's now 6-year-old son, 2 nieces, 7 nephews, extended family and friends. On Sunday the 20th of October 2024, my family were handed a life sentence when Deng Chol Majek launched a frenzied and unprovoked attack on Rhiannon for no apparent reason whatsoever. There is no end to the pain or suffering we've had to endure or continue to experience. On that horrific day, our precious Rhiannon was shown no mercy. Throughout this trial, we have been given no reason as to why he chose Rhiannon, no accountability for his actions, and no remorse. She fought for her life and to save herself from this sick, twisted, and cowardly human. We will continue to advocate to evoke change in her name. Many have tried to imply that this is about immigration, but these are the choices of one man, not an ethnic group. I would like to quote Rhiannon's favourite Disney character, Stitch. Ohana. Ohana means family, and family means no one gets left behind or forgotten. Rhiannon will never be forgotten. Thank you.